Move to open the meeting.
Second.
Do the roll call. Colby?
Colby Streeter, present. Rod Musil, present.
Darlene, yes.
And Vicky, yes. So welcome everyone today to our meeting. Just if you haven't heard, we have Colby, Robert, Darlene, and Vicky, the chair. We will be very focused on the question and points once we get to the hearing. In the meantime, if you haven't signed in, please do so. Yes.
I made a motion and you didn't vote me in as a full member yet, so
Oh,
I
okay.
forgot.
All right.
I was a full member and now I'm an associate and I'm not used to that.
All right.
So.
Should we start over?
Probably.
All right, so before we get going, I'd like to appoint Darlene as a full member of the ZBA for purposes of this meeting.
All right, move to open the meeting.
Do we have a second?
Second.
Roll call, Darlene.
Yes.
Vicky's yes. Robert?
Yes. Colby, yes.
All right, so this time, just as a reminder, speakers should be recognized by the chair. We're going to try to minimize back and forth. So if you're on Zoom, you can raise your hand using the little icon there if you can, or come off mute. We'll work to recognize everyone when we have the open period for discussion. It's when you are recognized, please identify yourself, and if you are representing yourself or if you have an affiliation with another organization or committee, so we have a context there. All right, so do we have a motion to open the hearing?
Make a motion, we open the hearing for 1 South Street Historic District Commission appeal of building commissioner's determination.
Second.
Roll call. Colby?
Colby, yes.
Robert?
Yes.
Yes.
Darlene? And Vicky, yes. So we will open the meeting. Robert, would you do the honors of reading the announcement, the legal ad? Thank you.
Okay.
Do you have them?
I got it. Accordance with Mass General Law, Chapter 48, Towns and Zoning Bylaw, Towns and Zoning Board of Appeals will hold a public hearing Wednesday, August 6th, 2025, 6:30 p.m. in Select Board Chambers, 272 Main Street, Townsend, Mass, on the application of Historic District Commission for an appeal under Zoning Bylaw 145, Chapter 64, Appeals, Code of the Town of Towns. The applicant hereby appeals the building commissioner's letter dated April 17, 2025, including all attachments regarding the property at 1 South Street, Townsend, Mass, specifically addressing the trestle structure and its location within the Townsend Historic District 2. Parties wishing to speak, support of, or in opposition to this application may do so at the hearing or in writing prior to the hearing. Copies of this application are available for review at Town Hall during business hours. Remote meeting options provided for convenience, and I'm not going to read all of that. Victoria, Chair, Zoning Board.
Thank you, Robert. Adam, would you like to introduce yourself?
Sure. I'm Adam Costa, Town Council.
Would you like to make any statements at this time before we get going?
So I will. I'm going to step up here so they don't have my back to half the room. Beth had gotten authorization and requested that I be present, just because I don't think that your board gets all that many administrative appeals. So just to sort of lay the groundwork as to what this is, what your role in this process is. I was hopeful that that was going to be simple because I attend meetings like this on a regular basis and I give this generic guidance on a regular basis. And then I got a full copy of the submittals yesterday and reviewed them partly yesterday and partly today and found more problems than I would have liked to find. So I'm going to talk a bit about the process and then I'm going to talk about a few concerns I have with what you have before you. and then leave it in your hands to continue the hearing. So zoning boards of appeals perform really three chief functions. They do some other things like they sit on 40B hearings, for example, but for the most part, ZBAs hear variances, special permits, and administrative appeals. Those are the three types of actions that come before you under Chapter 40A. There are three separate sections of 40A. Section 9 deals with special permits, sometimes Section 6. Section 10 deals with variances, and Sections 8 and 15 deal with administrative appeals. Administrative appeals are probably the least frequent of matters to come before ZBAs. I recall years ago, I was in the audience at a board meeting, a ZBA meeting. I did not represent the board, but I saw the board go to war with an applicant, telling the applicant that their application wasn't a variance for special permit, and they had no authority over anything other than variances and special permits. But what it was is it was an administrative appeal, and unfortunately their counsel was not there to guide them and tell them, absolutely, you have jurisdiction over administrative appeals. It's right in the zoning. So the bad news about administrative appeals is that unlike variances and special permits, which the statute and your bylaw give you guiding or defining standards, there are no standards when it comes to administrative appeals. There's no three-part test the way there is with variances. There's no 6 criteria the way that you have 6 criteria for the issuance of a special permit in your bylaw. There is no guiding standard. You are sitting effectively as a judicial board of sorts, a tribunal that is hearing the evidence before you and making a decision as to whether one party is right or the other party is right. In this case, it's a petitioner. The Historic District Commission has made a petition to your board. And the respondent, for lack of a better term, is the town acting through its building commissioner. Building commissioner issued a letter. That letter was appealed to you because the Historic District Commission disagreed with the contents of that letter. That is what the Zoning Act provides for. It provides for an appeal of zoning determinations issued by a zoning enforcement officer. In this case, that's your building inspector. So that's the sort of 30,000 foot view of what administrative appeals are all about. If an administrative appeal comes before you, you hear the evidence presented by the petitioner. You would typically give the respondent an opportunity to respond if the respondent is present. Sometimes with these appeals of building commissioner determinations or building inspector determinations, the building inspector or commissioner doesn't come before you. They just rely upon the papers that they've submitted. Sometimes they'll submit a response to the petition or appeal that's filed with you, as was the case here. And you consider all that evidence. You close the public hearing when you believe you've obtained all the evidence you need, and then you deliberate and you vote. To overturn the decision of a zoning enforcement officer, you're a 5-member board that requires 4 out of 5 votes. So just to give you the lay of the land. So let's talk a little bit about what's before you and the concern, a couple of concerns that I have. So the paperwork is in order. You have an application form. Historic District Commission identifies itself as the applicant or the petitioner, defines the property that's at issue, has supporting documentation in terms of a written letter explaining the basis for the appeal, a copy of the building commissioner's determination that is being appealed, and then some supporting paperwork. And then I've seen since then that provided for your benefit was some references to state law and the zoning bylaw and the general bylaw. And then I saw a response that was provided or I guess a supplemental submittal that was made by the Historic District Commission on August 4th, which was Monday, that provided some additional information, including a letter from the Mass Historic Commission in response to an inquiry that was made about this particular property or this project. So in terms of the paperwork, it's all in order. The issue for me is really more a process or procedure issue. So as I said before, when I described administrative appeals, we're all acting in the context of Chapter 48, the State Zoning Act. That's the statute that gives you the authority over administrative appeals. And what is an administrative appeal under that statute? It is a determination made by the town zoning enforcement officer, in this case, your building inspector. It's about zoning, about something being compliant or non-compliant with zoning. I've seen administrative appeals concerning determinations by a building official that a property can't continue to be used for a particular purpose because it's not pre-existing non-conforming. I've seen denial of building permits on the basis that the use isn't allowed or the structure can't be built where it's proposed to be built on the site. And those can be appealed to you, and you look at your zoning bylaw and you determine, is this project compliant with the bylaw or not? And if you find that it is, and your building commissioner said it wasn't or isn't, then you might overturn that determination. Well, what's being alleged here, as best I can tell, and obviously you're gonna hear from the petitioner tonight, and they'll tell you if I'm mistaken, but as best I can tell from the paperwork, is a challenge to a letter that was issued by Mr. Garside, concluding that this project at issue is not within the historic district, specifically what's referred to as historic district 2. You have multiple components or areas within your historic district bylaw. Historic districts are not zoning districts. Historic districts are created pursuant to an entirely separate statute. They don't arise under Chapter 40A. You don't adopt them as amendments to your zoning map or your zoning bylaw. Historic districts are created under Chapter 40C of Mass General Laws, which allows for the creation of historic districts, designation of properties as being within those districts, designation of a boundary that encompasses the district, and then provides for a process and procedure whereby historic district commissions in cities and towns across the state can administer the protections that are meant to accompany those sorts of districts and ultimately issue or refuse what is referred to as certificates of appropriateness for projects as to whether they're appropriate for the site. And there's a whole, there's multiple sections to the statute. I can't even remember the number. 15, 20 sections to the statute to go through all the details of the authorities that historic district commissions have. There's also a separate statute, Chapter 40, Section 8D, I think it is, that addresses historic commissions. And in some instances, historic district commissions are given all the authorities that historic commissions have. That's how it operates here in Townsend. And so there's another statute that gives the historic district commission even additional authority, but all of this authority derives outside of the context of zoning. So the first question I have when I reviewed these materials is, why did this question ever get presented to your building commission? Your building commissioner performs a couple of different functions. He functions as a building official under the state building code to administer the code requirements. And then he functions as a zoning enforcement officer under the zoning code, the zoning act, Chapter 40A in your local bylaw. Those are the two hats that all building commissioners, all building inspectors in Massachusetts wear. They administer the state code and the local ordinance or bylaw within the framework of the state zoning act. There's no authority. I reviewed your historic district bylaw. There's no authority in your historic district bylaw that is provided to, given to, conferred upon the building commissioner or the building department to make determinations as it relates to the historic district. And so my first question was, well, why did this question even come to the building commission? It did, and the building commissioner responded, and then of course it was appealed and is now before you. So that is my next question, which is, well, why is it before you? Because if it wasn't before the building commissioner in the first instance properly, how do you even have jurisdiction to make a determination? Because what you're being asked to do here is to determine whether or not the building commissioner was correct in making a zoning determination, and yet there's no zoning determination to be made from my perspective, because this isn't a zoning question. This is the question of whether or not a particular project, a particular property is within the boundaries of the historic district 2. But that's not a zoning district. It's not a zoning issue. And you're a zoning board of appeals. So that's sort of my procedural issue is I simply don't know that you have jurisdiction. Now, could you choose to proceed? I suppose you could. I think that the Historic District Commission is sort of proceeding at its own risk, as if you render a determination that's not to their liking. I suppose their option then is they could attempt to appeal that to a court of competent jurisdiction, a land court or superior court. I'm fairly certain that when this gets to court, that's going to be the first issue. Is, does the court have jurisdiction? And I'm fairly confident the court's going to say you're in the wrong spot because this is not a zoning issue and it didn't follow the proper process or procedure locally. There are some references within the state statute that deals with historic district commissions that talk about its authority, the process of applying the protections of the historic district, what it can do in the event of non-compliance with historic district requirements. None of those references, none of that authority points them in the direction of the building commissioner or any building inspector or any building official, and certainly not in the direction of the zoning board of appeals. So I'm not telling you not to hear the matter, but I'm sort of telling you that you probably shouldn't hear the matter. And if you do hear the matter, I'm not quite certain that you have authority to render the sort of determination that's being requested really by either party, because I don't know that it's before you.
Can I ask a question?
Sure.
Wouldn't that all depend on why it got to the building inspector or the zoning enforcement officer in the first place? what brought it there?
Yeah, so I don't know the background because
Yeah.
I'm looking at the paperwork and literally for the first time yesterday. So I don't know the background. I don't know how this came, and I think I saw that at least Mr. Garside's name is on the screen. So maybe he didn't want to speak, maybe he does, but it looks like he's at least in attendance virtually. So maybe he'll have some additional context to offer. Maybe the HDC will have some context. They may know,
Right.
suspect they know more than I do about this. I've only looked at it for 24 hours. So I don't know how it came to him. I do know that in performing the usual functions of building officials, a building inspector or a building commissioner in issuing a permit often has a checklist. And that checklist will include the sorts of things that are clearly within the purview of the building department, things like state building code compliance and zoning compliance, but will often also have checkboxes for, did you get your order of conditions if you needed one from Concom, even though that's not within the purview of the building department? Did you get a Title V permit from Board of Health? Did you get a certificate of appropriateness from the Historic District Commission if required? And so it could well be that when a request was made, he was looking at those checkboxes. But again, I don't want to put words in his mouth, but sometimes that's how matters get funneled to the building inspector, but that doesn't give the inspector or the commissioner any greater authority to act in those areas that are beyond his or her purview as a matter of state or local law.
You just added an interesting piece. to
Yeah, I
it.
mean, it's not a piece I wanted to add because I think everybody would like to resolve the substantive issue.
Yeah.
And so I'm not trying to complicate things, but at the same time, I read through everything and I had to read through it again because I'm like, why are we at the zoning board of appeals? I just couldn't quite get it. And I'm still not sure that I do. I'm not faulting anybody. I did look and I saw the letter, and again, to Mr. Garside's credit, in the letter that he issued, a copy of which was attached to the appeal. He said at the end, I have reviewed the HDC bylaw, the Historic District Commission bylaw, and see no vehicle for appeal of my decision. Therefore, I must assume that if you are aggrieved by this decision, you have 30 days to file an appeal with the ZBA. I would refer to town council to confirm this if you so desire. So it would appear that even the building commissioner wasn't entirely certain. He did his due diligence and looked at the Historic District Commission bylaw and said, well, there's nothing in here, and I can verify this, I reviewed it too. There's nothing that speaks to a mechanism for appeal. And so that's silent. And so he deferred to what he knows, which is most things that come before him, if they are to be appealed, need to be appealed within 30 days to the ZBA. But those are zoning things. And in fact, if it were a building code thing, it wouldn't even come to you either. If it were a building code determination that he made, that would go to the State Building Code Appeals Board, and that's a 45-day appeal period. So all these intricacies of the law in terms of where you go is directed by different state statutes and local ordinances and bylaws.
Thank you very much.
Yeah,
So at this moment, I think what we should do a quick discussion of, do we want to move forward with the hearing? Do we want to restructure here? Yeah. What do you feel?
there's unknown, we don't know. If we knew there was no jurisdiction, we wouldn't continue, but we don't know that. I don't know what the problem was that got us here in the first place. Our job is to either uphold the building, zoning enforcement officer, it's the same person, zoning enforcement officer's decision or not, based on our interpretation of the bylaw. I don't know why, how did he come into play? Maybe this can be answered. I mean, we could decide afterwards, after maybe we get answers to those things, decide, no, we don't feel that we should move forward.
So you want to move forward with it?
I think so.
How do you guys feel?
There seems to be a problem somewhere. Why not get it out?
I think we need more information. Like he was saying, it's not a zoning issue technically. So I think we need more information from the people that are applying for this, whatever it is, and give us more information.
I have a question. Why do you say it's not a zoning issue?
Well, like he was saying, the historic district is not a zoning district. Historic district is separate from a zoning district. So,
But we don't understand what their problem is with it.
yeah, exactly.
So,
So we need
yeah.
definition of all.
I certainly see a procedural issue here with going forward. But if we're asking, if the building inspector is asked to determine whether or not the property is within a historical district, then the responsibility is sort of on him to determine whether or not they should be notified about um, the building project on those properties. But to Adam's point, yeah, a district does not fall within our jurisdiction. Within being a zoning bylaw question.
So I agree with Darlene, I think that moving forward, we may get to the end of this and have may at that point figure out what we want to do. And once we've got more information, we've got Bob on the call, maybe we can get some background that'll help us resolve it. Or suggestions on where to go next.
Right.
Okay, so,
Can I interject for 1 second? Do you normally recognize people who are recording other than the town? We have someone here recording the session. Do you
it's a
want-
public meeting, so it's allowed.
Okay, thank you.
Not used to that.
Yeah, not new. New for me too, but it's allowed.
We're not
As a
normally
public-
that
as a
popular.
public open meeting. If we, for
Yeah.
whatever reason, went into an executive session, which I don't think that we ever would, but that would be, there wouldn't be any recording at that time, either by Zoom or a private citizen.
Thank you.
All right, so what I'd like to do going forward is, read the letter that is under appeal, decision is under appeal, is, our zoning enforcement officer the opportunity to maybe answer some of the questions that came up. Then have the historic district commission present their side. And at that point, we'll see if there's any additional feedback from the public or report. And at that point, we will start discussing. I think at that point, we close the hearing and then we'll talk.
Once the sites get everything out, then we'll ask if there's any other, comment.
All right, so, would anybody like to read the letter? From our zoning. Let's get my glasses on. Make sure I get the right one.
Do you wanna read the historic district letter?
No, the building inspectors.
Oh,
Just so everyone can hear the points before we move to the historic district.
I'll read the 17th. I got it ready.
Great, thank you, Mary.
So this is a letter written on April 17th from Robert Garside, the building commissioner, building enforcement officer, to Mary Jane Churchfield, chairperson of the Townsend Historical Commission. And this is regarding work on trestle adjacent to parcel 33430-1 South Street. Ms. Churchfield, over the last several weeks, we have been discussing whether the work on the trestle adjacent to the parcel above falls under Historical District Commission jurisdiction. My initial determination was that this work is not under HDC jurisdiction for approval due to the type of work being done, i.e., the on-grade work is excluded from HDC oversight per our bylaw. This determination, I find, is in fact incorrect. To explain, I offer the following. 1, in 1978, the 1978 filing with the state regarding Article 22, town meeting vote of Historic District 2 for the town of Townsend, see Exhibit A, clearly describes the historical district as being made up of properties, underlined. There are several instances where the word properties is mentioned. 2, in our current bylaw, see Exhibit B, the district boundaries are again noted and distinguished by properties. Number 3, nowhere in the bylaw of the HDC does it describe the historic district boundary set by meets and bounds. I have attached an example from Groton, Mass, Exhibit C, showing this type of description. Therefore, I have attached two current maps, Exhibit D, showing an excerpt of what I believe to be the properties, in capital letters, that are part of the Historic District 2, based on my reading of the 1978 maps and the property locations. Therefore, based on the above, it is my determination that the property with the trestle is not part of the HDC district, and therefore the HDC has no purvey over the work being done on this trestle. This is my final determination based on all the facts, including information you have supplied. I reviewed the HDC bylaw and see no vehicle for appeal of my decision. Therefore, I must assume that if you are aggrieved by the decision, you have 30 days to file an appeal with the zoning board of appeals. I would refer to the town council to confirm this if you so desire. I consider this matter of closed unless some additional concrete evidence to the contrary is presented for consideration. Again, that is from Building Commissioner Robert Garside. There's a second letter, though. Does that fall? Do you want to like just do both, or is there in between?
Maybe we should do this, please, put it together.
Want me to read it?
Yeah, we have it.
Yeah, okay. Okay, there's a second letter, dated July 28th. And this is to the Zoning Board of Appeals, regarding additional information regarding HDC appeal. Please allow me to provide additional information regarding, I think it's regarding my decision of the HDC Historic District boundary that is being appealed by the HDC in your meeting of August 6th, 2025. Attached, please find excerpt from the MGP Chapter 40C, Section 3, with regards to the establishment of an historic district by towns and cities. You will note that the establishment of sites, structures, and buildings are all to be indicated by parcels or lots, i.e. properties. The attached further supports my decision that the district is made up of properties, as I stated in my April 17th letter, points 1, 2, and 4. I respectfully request this information be entered into record for this appeal, and that the board uphold my decision that the trestle in question is not part of any property of the HDC district, and the HDC has no purview over the work being done on it. And then there's attachments. I'm not reading that.
Yeah. Okay,
Okay.
thank you. So this time, maybe Bob, our zoning enforcement officer, can you provide some background on why this came to you? And why
Well, can I ask a question first? Can we go backwards just a little? Adam, would you mind answering? I just want to make sure I'm clear. Was the determination by you that I am not the enforcer of the historical district, and I don't have the authority to do that? Is that what you said earlier?
So I didn't see anything, Bob, that led me to think that you did.
Okay.
Full disclosure, I've had the materials for 24 hours, so I can't tell you that I've done hours of research on it, but I
understand.
I reviewed the state statutes again, which I know well. I took a look at the town's bylaw provisions. I took a look at the excerpts from the town meeting votes when those bylaw provisions were adopted, and I just didn't see anything that indicated that determinations relative to anything relative to the historic districts, whether it be the boundaries of the districts or properties being subject to the district requirements, or what triggers the applicability of those requirements. I didn't see anything that directed those questions to the building department.
Okay, thank you very much. So maybe this was an error on my behalf. In Groton, my other town that I work in, I am by bylaw the enforcer of the historic district. So probably a natural assumption that every town, typically zoning laws, they're mostly, let's all face it, they're mostly all the same in every town with the exception of a few tweaks. So I probably assumed that I was the authority having jurisdiction, for lack of a better word, for the historical district in Townsend. That being said, if the case is I am not the authority and I have no purvey over it, I'm not really sure what you need from me. Because my determination apparently doesn't matter. If I have no authority over it and it's not my job, quite frankly, for lack of a better word, then I'm not sure what other additional information you would need from me.
I don't understand what got him, what
What
is
got
some,
him to the point
yeah,
where you
how did
So-
we get
so
here in the
the-
first place?
My assumption was that I was the enforcer of the historical districts, and if someone was doing something wrong, I was in charge of writing the letter and telling them they were in trouble, they were fined, just like any other zoning determination I would make on a normal day-to-day basis. There was work going on the trestle as part of the, I guess, the rail trail reconstruction, for lack of a better word. And that one of the historic district was requesting that I review that because they believe that the work at the trestle should be under the purvey of the historic district, and they should be able to approve the final design, look, whatever you want to call it, of any work that happens on the trestle.
So they requested your assistance.
Correct.
Maybe we should hear from the historic commission to
Yeah.
find out where the problem started. Like, I don't know what the problem is.
The problem is that there was work done on the trestle that is not in line with the neighborhood historic district look, for lack of a better word, and that the historic district believes that they should have purvey over the final outcome of what that trestle should look like if it is in fact in the historic district. If you have a house and you're going to put in new windows in the historic district, they would have purvey over approving what window look you would put in there. Same thing with if you put up, but whatever, an addition or whatever the case may be. In this case, it is railings on each side of the trestle that keep people from falling in the water when they use the rail trail.
Yeah.
So
Adam, did you want to respond? Okay, go ahead.
I have a question. So the trestle had some work done on it. Did you issue a building permit to somebody to do that work?
No, actually, I'm sorry, I cannot say that. I don't think I did, to be honest with you,
Okay.
because it's a bridge trestle. Typically, building does not have purvey over bridges and trestles. I would
Yeah.
not issue a permit for someone to rebuild a bridge. That is something I would not do.
So Bob, you issued this letter that we read, that the chair read into the record, dated April 17th, the letter that prompted the current appeal. The letter is addressed to Mary Jane Churchville, the chairperson of the Historic District Commission. It says, Ms. Churchville, over the last several weeks, we have been discussing whether the work on the trestle falls under the Historic District Commission jurisdiction. Was there a request made of you by the select board, by the Historic District Commission, by the chair of the Historic District Commission? What prompted you to write a letter? Because you wouldn't typically write a letter just of your own volition, right? You'd only write one if somebody asked you to and render a determination or make a decision.
There was work done. Yes, there was work being done on the trestle. I was requested to review it, and I want to say enforce it, but I don't want to use a bad word, but to basically, if it is an historic, go look at it. If it's in the historic, deal with it. Basically, like a zoning enforcement. Someone's complaining about noise, you handle it, you write the letter. So after reviewing everything regarding that trestle, it was my determination, still is, that it is not, the work of that trestle is not included in the Townsend Historic District number 2. So it is outside of one of the parcels. It is not included in a parcel, and therefore it is not. They have no jurisdiction over what happens on that trestle, or the railing system, I guess, that goes on that trestle, or the repairs, or whatever the case may be. So that is what prompted. I was asked to basically, I want to say, enforce it. just like we talked about today, we had the same issue down on Main Street today with, a request for enforcement of some work that is going on down there that is actually in the HTC.
And so that's, again, setting aside for the moment the fact that this is not zoning. If it were zoning, that would be a proper process. I mean, that's how most of these matters come to a ZBA. If it's not an actual application being made to the building department for a building permit, it's because somebody has come before the building commissioner or building inspector with a complaint or a request
Right.
for enforcement. And then the building commissioner by statute, if it's a zoning matter by statute, the building commissioner is supposed to respond within 14 days to a request or a complaint for zoning enforcement and render a determination. The nuance being that this isn't zoning.
So it sounds like if the historic commission is aggrieved in some way, they have to go see somebody else.
That would be my opinion. I mean, I think that where you've opened the hearing and you've all determined you need additional information, there's no
Yeah.
harm, everybody's here.
Yeah.
And hearing out both the building commissioner and the HDC as to what the substantive merits are. And then ultimately you can choose to deny the appeal on a jurisdictional basis if you want to. When you're done with that, you can choose to deny it on the merits if you want to do that. You could choose to deny it on both. That's up to you once you're done.
Is there any other questions, or Bob, do you have anything else at this point?
No, I have nothing. I really have nothing else to add. I mean, it basically speaks for itself. Obviously I made a grave error. And like I said, it isn't because I feel like it, but to be honest with you, the building department is probably the armpit enforcer of the town. So anything that's a problem, doesn't matter what department it is, it comes to the building department to enforce. So
Yeah.
because I am
We're all learning here, so.
yeah, no, it's fine. Because I am the enforcer in Groton, I naturally assumed that I had the enforcement responsibility here. So I apologize if it caused harm, waste of time, etc. It wasn't the intent. I will just stay out of the HTC. The question, I guess, is who is the enforcer of the HTC?
Well,
HTC?
Hey,
we'll come to that later. So,
Okay.
we're going to move to the HTC now. If you're good, okay, so let's go to the HTC, Historic District Commission. Is there a representative who would like to present, your case?
Yes, I'm Mary Jane Churchill, but first, I would like to call to order the HDC meeting because I have a quorum here and I don't want to violate the open meeting law. So I'd like to call the time, 7:07, I'd like to call a meeting of the Historic District Commission at 7:07. I'd make a motion to open them. Second, all right, it's been opened and seconded. Can I have a roll call, please? Clerk Alvin, present. Susan Gerken. Maura Shepard.
James Baronian.
Mary Jane Churchill. Mary Ann, Marie, I think is on.
Maria Milliken.
Has she been sworn in?
Yes.
Yes. Okay, all right, we're involved.
Thank you for following the proper process.
You're welcome.
Okay, so the agenda is to discuss this application.
Do you want to come up here? So I don't know if the
mic's gonna
microphone
pick
is
you.
going to get you.
Oh,
So, thank you.
so do you have questions or do you want me to give my thing?
Can you tell us how this started?
Yes.
Yeah.
Okay, so, I am the chair of the Historic District Commission, and I noticed that work was being done on the trestle in the harbor. So I called the building inspector, because the building inspector is in fact the enforcer for the Historic District Commission. So I called him and I said, there's work being done, they have not come before the commission for a certificate of appropriateness, and I'd like you to tell me what's going on. Oh, no. First I called Bill Rideout, who is the head of, to my knowledge, the head of the Greenways rail trail, because I thought it had something to do with the rail trail.
Okay.
And Mr. Rideout told me that work was being done and we, HTC, had no jurisdiction. So I said, okay, then I called the building commissioner, and he did listen to my complaint or my request to go down there and find out what's going on. And he decided that because they were not working above grade, that we didn't have any jurisdiction. So it's fine. Then the next picture shows they're putting up rails. Now we're above grade. So now we do have the authority to jurisdict it. And so I went back to Mr. Garside and I told him, he said, no, we have a difference of opinion. And if you don't like my opinion or my determination, then you have to go before the board, zoning board of appeals. So I'm here because he told me I should come to you. And I guess nobody knows what we're doing. But the bottom line is that we in fact do have jurisdiction. And if you will look at the packet that I sent, you'll see a letter from Michael Steinitz from the Massachusetts Historic Commission. He's a deputy director of the commission.
Let's not go there yet.
Oh, okay,
I have a question.
okay.
That's if we have jurisdiction, we'll go there. Or if it's our purview here. You said they are doing work on the trestle. Who's they?
Well, I'm not sure. I don't know, because no one came before us with an application, so I can't answer that question.
So, no, so somebody
Somebody,
showed up and put railings on the trestle.
yes.
Somebody did improvements
Nobody
with the
knows-
trestle, didn't get a building
Nobody
permit.
knows who it
doesn't-
was,
Yeah.
or how they did it, or,
Well, I don't know who it was. I mean, I would know
Who's an
if
actor?
someone. Excuse me?
Sorry.
Well,
Just joking.
the two people I spoke to were Spanish, so that was not gonna work for me. So,
so is this appeal that somebody put railings on a trestle?
no,
Or is it that you don't want the trestle touched, or?
no. The appeal is the determination of building Commissioner Garside that the trestle itself is not in the historic district. Because once that's established, in other
So
words,
if it's in the historic district, then what?
then whoever is putting up these rails and doing all the work has to come to the historic commission for
Yeah.
a certificate.
Yeah,
And then whatever
so
happens
if
after.
the way I understand, if the bike trail people want to expand the bike trail, and it has to go through that, they gotta get a permit from you?
Well, let's be real clear on this. That
Yes.
trail does not go there. The trail stops at 80 Main Street, which is the Harbor Church. It stops there, which is why there's an easement that the Historical Society gave to this rail trails, whatever they call it. And you're supposed to stop there at the church,
Mm-hmm.
take your bike along the easement, which brings you to the sidewalk. You go on the new sidewalk that's just been put in for the specific purpose of the rail trail. And you take the sidewalk to the intersection and you go over the intersection and you hook up on the rail trail on that
So-
side.
The sidewalk was put in just for the bike trail?
Correct.
The rail trail kind of does a, yeah, but
So,
that's,
all right, so
that'll-
you're
that'll
coming
get
down
us
the
off.
bike trail, you stop, cross the street,
You go down, you take the
Down.
easement and you get on
and
the
then
sidewalk.
back, you can't go across the trestle. Why?
Well, number one, it's not owned by the historic district, and the rail trails before my time made an agreement that they weren't, maybe Claire, Calvi can speak to that because I wasn't on the board.
Wouldn't it be easier to just keep going?
I think that's
straight?
already.
but this, we don't,
established.
I
Yeah,
don't,
we
we're
can-
getting into the rail,
Yeah.
what the rail trail people did and what was approved is not our purview.
No,
And if the historic
I'm
commission has a
just trying to
problem with that,
figure
that's
out-
not our purview.
What we're,
I'm trying to
talking
figure
about.
out why we're here, like what,
yeah,
so
We're here
you
because of
reached out to
Bob
the building inspector about some work being done. He thought he had jurisdiction and he doesn't. Right there, that spells out, the historic district commission has a problem with whatever that happened on that trestle. They have to go to whoever did the work. And I
but
think
he's our
Mr.
enforcer.
Garside said he didn't give a permit or didn't have any oversight of that, which I don't understand. How could any kind of thing be done for safety or building a structure without a permit or some sort of
Unless it's part of a-
oversight? can anybody answer that question? Who did that work? Okay,
I can answer the question of who did the work, but I can answer the question about how things can get done without
okay,
oversight.
that would be great.
Not everything triggers the need for a building permit. You wanna put up a
Sure.
fence in your backyard, as long as that fence is under 6 feet, you can erect that fence. And has to be zoning compliant, but in many instances, there aren't even setbacks for fences. Same thing with walls, certain height, 4 foot, I think it's above 4 feet under the building code, you need to signed off by a structural engineer. You wanna put a 3-foot wall up, you can put up a 3-foot retaining wall without any building department oversight. So I don't know anything about this particular project, so I don't know whether it triggered any of those code requirements, but the fact that work was done and the building commissioner saying he's not aware of any permit issuing, doesn't mean it's being done illegally necessarily,
Oh,
but I don't know anything about this.
I was making an assumption it had to have some sort of an approval.
Maybe not.
If it didn't, then that's different.
Of course, the HTC's
Well-
position is it requires their approval, their certificate of appropriateness.
Right.
I can
Right.
illuminate a little bit on that issue, if you like. I think the issue is the procedure was confused because it was covered under an OOC. Now we,
Can you say what a OOC is?
yeah, I just realized, an order of conditions through the Conservation Commission. And that was filed by the Squanicook Greenways. Now, we don't cover anything that's built. We cover the conditions that things are built under. Meaning that, you know, that a tarp was required to be put under that trestle while it was built, while it was reconstructed. And I think that created confusion where that seemed like a permit to the Squanicook Greenways, and in actuality, it is not. So I hope that helps
Well, there was no,
explain how it got to that point.
oh, you mean because I called you? Oh, I did, after I couldn't get anywhere with anyone, so I went to the, Conservation Department. And I asked to see what was approved, and I had a list. Actually, I called the regional in Worcester, and I spoke with the woman there, and she told me what I should ask for, and I received it. And when I went down to do inspection on the trestle, there was no tarp underneath, and different other kind of things that you're not concerned with. So I again went back to Building Commission Garside and explained my concerns. And I guess the butting of the heads came is that I believe that we are in the Historic District Commission. And the building commissioner believes we're not. That's actually,
I understand that
What
part of it.
and that's all,
But
that's all I want resolved. And if you're not the ones to resolve it,
We need to figure out.
Who
right,
is?
right, who is? I
Who
guess
is?
is the question.
Okay,
Yeah.
yeah.
So, my name is Bill Rideout. I am the treasurer of Squanicook Greenways. Back in 2015, Squanicook Greenways signed a lease with the MBTA, taking control of the MBTA property all the way from, well, the towns, beyond Townsend border, but from our start of Townsend border, and we go to just around Worcester Street, and that's where our lease actually ends at the moment, where we do expand it. So we have leased that from the MBTA. MBTA is still the owner. They have the right to take it back. The only right we have on that railroad is to build a rail trail, which is what we've been doing. So one of the issues that Mary Jane pointed out is that we were asked by the historic district not to remove the rails on the Green Homestead and the Harbor Church. So we agreed to not put the rail trail, continue that way. We did work with the town for many years to get the sidewalk in, which was finally done, and thank you very much to the town. But the trestle, we are also required by the MBTA lease to have liability insurance. And even though we are protected by the recreational use statute, which says that it really has to be something bad for us to get sued, it can't just be some random accident. We still felt that having railings on that trestle was something necessary to ensure our financial survival. And so, this trestle was actually built pro bono by Gary Shepard. We asked him to put railings in. He said, I don't know if I have money for that. and then you put it in, so. So that's where the railings came from. I wasn't quite sure if he was going to do it. Wanted him to do it for our liability reasons. But I do notice that people are using that railing now for fishing constantly. It's very popular, but that's not really the issue here.
Right.
But anyway, but we do have control over, we have a lease ownership of the entire rail bed, from Townsend border in Groton to, Mount Worcester Road. Right now, we are trying to get, permission to continue further, but, so we are the ones who are behind this, and we have inspect this. On, April 11th, 2025, I have a check paid out to the building inspector for building permit for trestle bridges in Townsend Harbor for $110, which was cash. So there was indeed a building permit.
Thank you for confirming.
It was,
Yes, it was a building.
it was cashed.
But that did not, okay,
So
I
what
don't
is,
know what it
yeah,
is. I just had to write, I'm just the treasurer.
so if the building department issues a permit for some work done and another community has a problem with it, then so now then,
So it's really no different, if I could through you.
yeah.
It's really no different than if the Conservation Commission is concerned that somebody is doing work. I mean, let's take Squanicook Valley. I mean, I presume you're some sort of a nonprofit.
Yeah, we're
Right,
right.
Right, so let's take nonprofits in the town. Let's pretend this is just Jack Smith who owns some property and is doing something in his backyard that his neighbors look and say, you shouldn't be doing that. You don't have proper permission. You don't have Concom permission. You need to go to Board of Health before you install that septic system. You haven't even visited the Board of Health. Or you need to go to the Historic District Commission because your property is historic and you're doing things with it that would trigger a review. What happens if the Concom is alerted to that and the Concom issues some sort of an enforcement order, or the Board of Health issues a letter, or the HDC knocks on the door and says, stop doing this, and Jack Smith says, thanks, but no thanks, and slams the door in their face? The recourse is not to the building commissioner. The recourse is not to the zoning board of appeals. The only reason this process exists is because you've got this state zoning act that says you have to exhaust your administrative remedies. It's called the exhaustion doctrine. You gotta go through all these local processes in the zoning context, make sure the building inspector and the ZBA both say it's okay before you show up in front of a judge. But in other contexts, HDC, Conservation, Board of Health, plenty of others, there's no intermediate process. So my answer to the question, I know I've heard Mary Jane say, and Ms. Churchill say on a couple of occasions that the building commissioner is the enforcing agent. I'm simply not seeing that authority anywhere. So I'm happy to be corrected if I'm missing something. As I said, I didn't read every sentence of your bylaws between noontime yesterday and noontime today, but I didn't see anything that gave him that authority. Unless there's some local authority vested in the building commissioner or somebody else, the recourse is to court, the same way it would be in any other instance. You got to go ask a judge to issue an order to require compliance with the historic district requirements, or require compliance with the wetlands bylaw, or require compliance with Title V, whatever it might be. That's the usual recourse in most instances where you have a board, commissioner, committee in a municipality that exercises certain jurisdiction, and you've got a property owner in town that is doing something in violation of the requirements of that jurisdiction.
You've been very patient.
Yes, Claire Colby. I have been on the commission for many years, and Susan will agree with me, I'm sure, that the procedure's always been, if you have a project you want to do within the district, you apply to the HDC for a certificate. If you're granted the permission, then you go to the building commission. If you're not granted anything by the HDC, then your project's now void and the building inspector does not issue you any permits.
Thank you. Anything else you'd like to add?
Yes, I would. Before we start, could I ask that you read the letter from the state into the record so that everyone knows?
I'm going to, I really don't think that's necessary. I've heard enough that I feel that they're in the wrong place. if the building commissioner doesn't have jurisdiction over them, then we have no say in any of it. I think the relief for the historic commission is just somebody else, not us. So I don't think there's any reason to read anything, do anything, it just muddies things up. It's just irrelevant, that's my opinion. So, there's, you want to have a discussion on, I don't know how you guys feel, but.
Why don't we get some more feedback, a little more,
Thank you.
yeah, then.
As I heard from Rob
Can you,
Garside,
identify yourself, please?
James Drawing.
Yeah.
Commissioner,
Thank you.
ETC, I'm sorry. If I understand it correctly, Bob said, I am not the inspector of this project, and who is? Could you enlighten me on this, Adam? He ultimately is, he is the inspector on the buildings and the facades and the work that's getting done. Mr. Rideout made a very important point here. The rail is owned by the MBTA. The water that flows underneath that is H&B's. We're looking at a safety situation here about as much as anything here also. Let's put all these pieces together. Can somebody tell me who is in charge of inspections in the SNO about any construction? Because it certainly can't be done by the Historical Society. Who is the body that ultimately makes the decisions? When permits come to the Historical Society, they're supposed to be probably marked that it is within the historical district area to bring it to the attention of the building inspector. Can you enlighten me who Wood is? The one that puts the ultimate yes and no on building projects in Townsend? If it isn't Robert, who is it?
If it requires a building permit, it's the building inspector.
Correct.
But,
But he's enforcing building codes
right,
at that point.
if it requires, if it's something that requires a permit.
Can I?
It's still not our purview.
For clarification, at what point in the building permit process does it cross the historic district commission's desk? To say whether it's in their district or not? Or
All right, so-
yes, please, Ron.
I can answer that. Typically in our software, which is not perfect, the software has been programmed with the historical district's addresses. So if I get a permit from 61 Main Street or 445 Main Street, it has a big thing that says this property is flagged. So that's my thing, and this happens, that's my catch. In most of the cases, it's not perfect, it's software. It's garbage in, garbage out. So that's my catch. And then I would give them the old, you need to go in front of the HDC or provide me the HDC paperwork. So that is how it works. So like we have one in yesterday, perfect example. 81 Main Street came in yesterday, wasn't flagged. Had to look at it because it was close. It is one unit outside the historical district. I made the judgment, looked at it. It is one parcel away, put a note on the file. It is not in the historic district, and move the permit along. So if it is an historic, it's flagged to me. Matter of fact, there was one, I think, 445 Main Street where the guy's looking for apartments would have went in front of the historic district. However, it was denied originally because the scope of work was denied. But had it been approved or had it been processed, it would have went in front of the HDC for approval if the guy was making changes.
And I think therein kind of lies the problem. It's a little bit circular, right?
Right, yeah.
If someone wants to take over looking at the permits and voting those on the HDC, I am all ears. All ears.
I hope that's water.
No, it's not. No, it's not. Would you, I'm sorry, I really have another Zoom meeting to go on to, believe it or not, it's my late night. Would you mind if I left? Would you guys have any problems if I left? If you would excuse me?
Yeah, I'm fine with that. I think you've
All right.
provided what we need. Thank
Thank
you.
you.
Appreciate it.
All right, thank you. I'm sorry. I'll stay out of it from now on.
Thank you.
Yeah, I do have a question. I'm a little confused about the zoning issue. Is the historic district not an overlay of the zone? No, it's not?
No.
Oh.
It's
Okay.
not, like,
It's not, but I will tell you, I feel for you and your confusion because it is shown on the zoning map. So you pull the zoning map up and it has, I pulled it up today and when I was looking through the paperwork, you pull up the zoning map and it has the outline in bright pink of the historic district. So it's overlaid onto the zoning map, but it's not, I then searched the zoning bylaw to say, well, somehow, some way has Townsend decided that they're gonna adopt this as a zoning district? Never seen it done that way. Not in, it's not, there's 4 references to the word historic district in the entire zoning bylaw, and none of them refer to the creation of a historic district as a zoning overlay or as a zoning district. So it's not, it's separate, it's created under the historic district statute as it should be. So the proper process was followed to create it, but it's not a zoning overlay.
So I guess I owe an apology to your board. Based on all the confusion and nobody knows what anybody's doing, I followed the direction in the letter. I understand you're not in charge, so I'm not quite sure where it leads to as far as the zoning of the historic district. So I apologize for wasting your time.
Are you allowing the public to, put 2 cents in? We'll do quick, yeah, if you can keep it quick.
I'll try. My thoughts are, just to quickly go over the process, is if this had been done the way the HGC wanted it to be done and thinks it's supposed to be done, applicants to do work such as building a trestle above grade, which is above grade, and I think it's in the historic district, but the normal procedure would be to appear before the HDC for a certificate of appropriateness. And they have some kind of hearing, an actual hearing. And then they can either approve it or deny it. But my understanding of the bylaw, and I think state law too, is that there's an exception to, or a reason why somebody could build something above grade. One of the reasons, if I'm not mistaken, is safety. Is that correct?
Yeah, right. Well, we never got to.
Okay, I know, okay. But since, just as a member of the public, I'm looking at this whole thing that's been going on for months, is, okay, you've got a trestle, they built a railing for safety, and there's people fishing off of it now, which I don't know if that's good or bad, but I mean, because people, to make it safer, regardless whether it's physically in the rail trail, but it's the real bed, and we've got all this, which is some other issue, not strictly the HGC's issue. So if this had gone, the HGC, if they had done a certificate of, gone before the HGC for a certificate of appropriateness, and they said, is this for safety? The HGC, I'm not putting words into the HGC's mouth, but maybe they could have approved it, because, okay, and it does, I don't think it looks horrible. It's definitely there, and I think it looks like it's well built. I went over and saw it myself, but it's a reason that the HDC could have approved it. And I'm just thinking like a mediator that, well, wait a minute, why don't they do it right? Just go get the certificate. I'm not asking anybody to make a decision tonight, but I think a good mediated solution could be do the certificate of appropriateness. Maybe the HDC would approve that because it's for safety, and everybody can go home happy, rather than this convoluted. In fact, Adams had to make, I mean, he's trying to help, and basically nothing, it's not in anybody's jurisdiction, and the HDC never got to really do their job, because we're arguing, or they're arguing, about whether, who has jurisdiction, and it's like, if they went back and just did the procedure, maybe everything would be fine, and we'd have a safe trestle.
Okay, so,
Yeah,
I
that's
think
just
we'd
my,
have to pause.
that's just my
Okay,
two,
yeah,
my
okay,
two cents on that.
is there anyone on the call that has something that can contribute at this point? That they would like to contribute? Okay, so, sure.
I'd like to, offer the fact that the letter that from the, Commonwealth of Massachusetts does clarify the fact that the trestle is part of the historic district. Okay?
Thank you. Right, so at this point, I would like to close the hearing.
Can I make one correction?
You may.
The application mentions that the property parcel is, where is it? 33430.
Yeah.
1 South Street.
Mhm.
Incorrect.
Not correct.
Yeah, it's actually 33440, and correct me if I'm wrong, which is a 0 Main Street address,
Mhm.
and the property owner of it is Holmesworth and Bose. Is that accurate?
No, it's not. They own the water rights.
They own the water rights. Okay,
Not-
but that,
not
the
the-
parcel ID and address are correct, or?
No, the address is wrong.
Can I make a comment on that?
Yep.
There is a lot of confusion about the property in that area. Well, there's a disagreement between us and me, but let me just give my opinion first. The MBTA owns that entire corridor, and at one point, Spalding Fiber owned property right behind it, on the other side of South Street.
Sorry,
And both sides
Who
of
was
South.
that?
Spalding Fiber going way back in 1940.
Okay, yeah.
They sold it to basically themselves. This Spalding Fiber, New Hampshire sold it to Spalding Fiber, Massachusetts. And they changed the wording of the lease such that instead of giving a definition of where their property boundaries were, they went all the way to the street and they said, well, except what the MBTA owns. So they added ambiguity into their lease, which they only got away with because they were selling it to themselves. And from then on in, it became a complete mess as to who the ownership is. But the MBTA feels that it owns all of that property yet.
Yeah, I would just say that the assessor's maps do show it as private property, not the MBTA.
That is correct. It's accessible back. They did not back then, but yeah, but it was a different parcel. Those parcels have been changed around. There's a long history of shenanigans
sure.
that have gone on there. But none of those parcels are listed in the Historic District Commission bylaw. All the ones are there. 1 South Street is, 2 South Street is, but that parcel is not.
Okay, so,
Whoever owns it.
is there any? Yeah.
Point of order, that's not accurate information.
Okay, that's really, all of that's really irrelevant in my, at this point,
Yeah, just want
you
to.
guys are at the wrong place to discuss all the details of it. It just doesn't, it's a moot point because we're not gonna make that decision.
Yeah, so you, Robert and
Yeah.
Colby, do you have, and Darling, enough information to close the hearing and go into discussion?
Yep, and move to
Yeah.
close the hearing then.
You have a
Yes.
second? Robert?
Yes.
Colby, yes.
Yes, and Vicky, yes. All right, so we're in the discussion phase. We're not taking any more feedback at this point.
You might have one legal question, right? I don't know. What decision you make.
So
That's the
we
motion.
can decide, if I remember right, so we can decide to uphold the building inspector's decision. What was it for?
You either uphold or go against it.
Go
In my
against it,
opinion,
or we can say why, whether it's jurisdiction or
oh,
zoning. Is that right?
Right, so this is a bit tricky. So you've got a petition before you. The petition is not the building commissioner's petition. The petition is the historic district commission's petition. And so to grant that petition, which would effectively have the result of overturning the determination made by the building commissioner, you would need to vote to grant that petition, and that would require a 4 out of 5 vote, and you only have 4, there's nobody. So it requires a unanimous vote, that doesn't decrease the quantum, it requires a unanimous vote of the 4 of you that are here. That would be appropriate if you were deciding to deny the petition on the merits of the petition, if you had discussed the merits of the petition, which you didn't, you discussed a bit, but not extensively. If you were gonna grant the petition, you could move to grant the petition and, or excuse me, if you're gonna deny the petition, you can move to deny the petition, but that would again presume that you're doing it on the merits of what was before you. If you're determining that you don't have jurisdiction, I think it's a different motion. I think it's, you're denying the petition, which has the effect of, I guess, affirming the determination of the building commissioner, but not really, because you're claiming lack of jurisdiction. It's a bit tricky when it comes to you in this context.
Yeah.
You can't undo what's been done already. You can only act for yourself. You can't say, we're voting yes or we're voting no, and we're also striking the building commissioner's determination from the record. What he's done, he's done.
Oh, so we can't make a motion to take no action, because then there'd be.
I wouldn't recommend an
Yeah,
action, a
no,
motion to
because
take no
there's
action.
another thing that can happen.
What, from what I've heard today, is that we don't have the jurisdiction.
Yeah.
And that,
Well, let me, if we were to uphold the building inspector's decision and he doesn't have jurisdiction, then does it matter?
Well, I mean, it matters in the sense that your decision supersedes his, right, in terms of the sequence. So I think that if your objective here was to determine that you don't have jurisdiction, and then in your opinion, the building commissioner didn't have jurisdiction either, all you can really do is act on what's before you, but you could move to deny the petition on the basis that this board lacks jurisdiction, and this board is of the opinion that the matter was not properly before the building commission. And then that's documented, and it is what it is.
And then what does that mean? Like, how does that?
Goes back to
That's never happened.
Goes back to the building commission.
I mean, it doesn't really go back anywhere, right? Because the historic district commission is here saying, we didn't get the answer we wanted from the building commissioner. They're gonna leave here if that were to be your vote, not having gotten the answer they want from you. Not so much because it's on the merits, but because you've determined you don't have jurisdiction. And they're in no different place than they were this morning, or quite frankly, back in March, before they got this letter from the building commission.
Well, I'm thinking about what action they could take out. We want to do the right thing so that if any action is.
Right, and so, I mean, they always have the option, I'm not advising this, but they always have the option of appealing any determination you issue, right? So they could appeal it, then they're gonna get to court and have to struggle with the jurisdictional issue, but they could do that if they wanted to.
Right.
They have options. You heard a mediated solution option. I mean, that's not for this board to decide, but there's always an option that they could try to mediate a solution and coordinate a friendly appearance before the commission under dispute. That's an option. They have legal options if they got authorization to take legal action. We talked before about that's how local public bodies pursue enforcement. Challenge there is they need the funding to pursue that legal action. They need select board authorization. It's not easy as a municipal board to just run around and file lawsuits. But those are all options they have. None of them are probably great options from their perspective, and I can appreciate that. But
They're not typically used to making negative motions.
well, it wouldn't be. It'd be again, the petition's before you. So if you're determining you don't have jurisdiction, it wouldn't be a negative motion. It would be a motion to deny the petition.
Okay.
Can we do that and add in a motion that would correct for how it was missed? Can we add in a checkpoint to try and correct the problem in the system where building permits go to the historic district
This is
commission?
a very odd situation that'll probably never happen again, because.
Maybe not. I mean, this is odd. This is odd on the substantive issue, and we haven't gotten into that of where this property lies and whether it's in the district or not, property versus the boundary. It's messy. In an ideal world, applicants are going to know what permits and approvals they need. When I represent private clientele and they're paying for counsel, we review the bylaws, general bylaws, zoning bylaws. We don't go to the building commissioner and say, here's the form, let's hope you don't check the boxes and say we need this relief. We determine what's needed and we tell our client, you need to go to HDC, you gotta go to Concom, you gotta go to select board. Not everybody has counsel. Not everybody chooses to go that route. Some just go before the building commissioner, and if it's not on the checklist, or if it gets through the system, because it doesn't, the address doesn't prompt a warning that it's in the district, or doesn't believe it's in the district, then it slips through the cracks. To answer your question directly, I mean, that's a legislative function, right? So you can't issue a decision, you're sitting as a panel of judges. You are acting on the case before you and saying yay or nay. You can't say nay, and I'm now legislating to say, here's how the law is gonna change so this doesn't happen again. That's not, that's the next step. I mean, this could be a lesson, and those who are watching this or hearing this can say, well, we gotta clean up the bylaw. We have to prescribe a process locally. We have to make sure this doesn't slip through the cracks in the future, if in fact this is believed to have slipped through the cracks. I know there's a difference of opinion on whether it did even. There's the building inspector's position, building commissioner's position is nothing slipped through the cracks. This is not in the HDC because it's not a defined property.
So the proper motion would be to deny the application based on the lack of, well, it's still an
Either
application, petition application, right? Based on the lack of jurisdiction of the board. Gonna make it that simple?
You can. You can.
I move to deny the application of the HDC Historical District Commission based on the lack of jurisdiction of this board.
We have a second,
Second.
Any discussion?
any discussion?
It became pretty clear to me, so.
Colby?
So, actually, I
You need
had a
discussion?
discussion.
Yeah,
Just a yes vote would mean that we do not have jurisdiction, correct?
we're denying the application because we don't have the jurisdiction, so it's
Okay.
basically,
Discussion done. Colby Streeter, yes.
Robert?
Yes.
Darrell?
yes.
Vicky, yes, it's unanimous. Tricky situation, I think this is, these type of meetings, it's, when they're tricky like this, bringing it together, bringing parties together is helpful, so I don't think it's a waste of time. I think it's good to get advice from experts here, so that we have a better understanding of what the right avenues are, so don't feel bad about that. And I'm glad to have a joint meeting with you guys as well. Do you wanna?
Thank you for your expert, help. So,
Yeah, sorry.
we all agree that you was great. You were
Well, I'm
here.
sorry it came so late. I mean, again, I wasn't involved in the process earlier, and that's fine. Things are busy in communities. But had I known earlier, I hope Bob doesn't feel like I threw him under the bus here. But, you know,
No, I think we all learned something because the historical commission hasn't been, in my, all that active in this, like, until as of late. Would you say that? Could you,
No,
or have they used to,
I don't
I mean,
think,
the last 5 years?
yeah, I
you've
think
been
people
active?
just are not very active, very
Yeah,
active.
but prior to that, I've never seen,
Well,
or,
we had that,
so there's a lot we don't know.
were you
Maybe we have to
involved in the
learn.
grooming shop application?
Yeah, Bill, is what, you don't know. Use a letter.
So,
Okay.
I don't know if you guys wanna close your meeting?
No, we're gonna go down.
They can.
Okay, okay. All right, so
Thank
thank you, everyone.
Thank
We're gonna
you.
move on to business.
It's a learning moment.
Thank you.
Thank you very much, Adam. Appreciate it.
Yeah, thank you.
My agenda here, so we can.
You chilling? Well, Michelle,
Won't be that long.
All right, so, next on the agenda is to approve the meeting minutes
From July 2nd?
from July 2nd.
Yeah, I read them.
Has anybody read them?
Yeah.
Do we have a motion to, any changes, What was the first thing?
No.
Good. I do a motion to approve.
Motion to approve minutes of July.
Second on the second.
Second.
Okay, Darlene,
Yes.
Colby,
Colby, yes.
Robert.
Yes.
All right, we're good there. Correspondence. Beth, is there anything here that we need to, is it informational or is there anything we need to discuss?
Informational, that came from, came from the building inspector. All of those letters are on file.
Meeting folder. Anybody? Wanna go through them?
I might just note that you do have an application, submitted for 159 for Plant
That's
Street,
false.
as you know already, but the site visit, is most likely going to be on the 20th. So, August 20th at 5:30.
And that is for the hearing is scheduled already for that?
Yes, the hearing is September 3rd.
I won't be able to go to that, site visit, so. If,
I noticed a couple errors in the application. And again, correct me if I'm wrong, but they answered no to the parcel being an aquifer protection overlay district. They did,
Are you talking about 159?
yes.
Yeah, we can't talk about it.
yeah,
Yeah.
not until we open it, so
Yeah.
it becomes public. We
Sorry.
can, yeah, make notes.
Yeah.
Here's you, we'll give you a.
Yeah, you're being good, looking ahead already.
I know.
Wow.
I
Right,
think that
so
was
on the
the
site
point.
visit, is there any other business?
No, with that in next meeting, September 3rd.
There's nothing to sign, so we don't really sign anything. We have a motion to adjourn.
Move to adjourn.
Second.
Oh, that double second. All right.
All
Darlene,
right.
Yes.
Colby,
Colby, yes.
Robert,
Yes.
and I say yes. Thank you, everyone.
Awesome.